I'm Jeffrey Eilender, the managing partner of Schlam Stone Dolan, LLP, and today I'll be talking about a concept that many lawyers have not heard of, and probably even more clients have not heard of, which is the litigation privilege. Now, the litigation privilege is something that protects a lawyer and a client from statements made to third parties about an adversary in a litigation. So the classic situation is there's a pending litigation and the lawyer writes to third parties about the litigation. Or the lawyer writes a threatening letter to a potential adversary in anticipation of litigation. And this privilege shields the lawyer from such activities under certain circumstances. So this was a privilege that was developed in California and in New Jersey and in some other states, and slowly became recognized in New York. And in these other places, the privilege is an absolute privilege, which means it doesn't matter whether the lawyer had a good motive, bad motive in what he or she is saying, or believes it's true or doesn't believe it's true. At least in New York state courts and the New York federal courts that apply New York substantive law, it's a little different. The rule used to be that before a litigation was filed, if you sent out a statement, it would be subject to a qualified privilege, which means that the lawyer had to have some basis to believe the statement was true and should not be acting with malice. But if the lawyer was discussing a litigation that had already been filed, that was already pending, or was trying to achieve a purpose for a litigation that was pending, there was an absolute privilege, which means it doesn't matter whether the lawyer thought what he or she was saying was true or not, as long as it related to achieving a litigation purpose and the client was completely protected. In 2015, the New York Court of Appeals changed the rules a little bit, and it held that pre-litigation communications are absolutely privileged, with the constraint that the lawyer has to believe that there's a meritorious litigation that could be filed. In other words, the lawyer or a client acting at the lawyer's behest can't just be sending out a communication just to be bullying or harassing, and particularly knowing that an anticipated or threatened litigation is not meritorious. But if you get past that, whether a communication that occurs before or after litigation, it doesn't really matter. It's absolutely privileged under New York law. And I just want to emphasize, these are not just communications made by lawyers, these are communications made by clients at the behest of lawyers. So if, for example, a client is trying to get information from third parties, or a client is trying to publicize the case and doing it at the advice of his or her counsel, that will be covered under the privilege. Now, in New York, there seems to be one other limitation on the privilege, which it may be that the privilege applies only to defamation. So if for some reason a client or a lawyer commits tortious interference that does not involve a defamatory statement to a third party, there is some case law out there that says the litigation privilege doesn't apply, and it looks like the litigation privilege may not apply to something like breach of contract. Again, the classic reason why some lawyer or client would need the privilege almost certainly, or very likely, be a statement made to a third party about the adversary, in which case you're well protected under New York law.